Good evening. My name's Dr. Matt Killingsworth. I am the Head of Discipline in Politics and International Relations at the University of Tasmania. It's my pleasure to welcome you to this evening's AIIA University of Tasmania event, Between a Rock and a Hard Place. Are we expecting too much of the International Criminal Court? To begin this evening, I would like to acknowledge that our presentation is taking place on land traditionally of the Moornino and Palawa peoples, and as a reflection of this institution's, of UTAS's recognition of the deep history and culture of this island, we wish to acknowledge the Moornina and the Palawa peoples, the traditional owners and custodians of the land upon which this campus was built, and pay respect to elders past, present, and emerging. Before I introduce this evening's speaker, a few housekeeping notes, and forgive me because a Zoom presentation is a little bit new for me as well. The microphones, audience members, your microphones, video, chat function, raised hand functions have all been disabled. However, I encourage you to use the Q&A function, which you'll be able to see on your screens, to ask questions throughout the evening, and I'll endeavour to get to those and ask Tim to respond to as many of those as possible in the time that we have. It's also important for me to inform you that this event has been recorded and will be later available for re-listening on YouTube and SoundCloud. It's a real pleasure for me to introduce this evening's speaker. Not only is he an esteemed scholar and expert in the subject matter, he's also a friend and a colleague. And many of you know Professor Tim McCormack as the Dean of the University of Tasmania Law School and as a Special Advisor of War Crimes to the Prosecutor of the International Criminal Court in The Hague. Tim was the Foundation Australian Red Cross Professor of International Humanitarian Law, the Melbourne Law School, and also the Foundation Director of the Asia Pacific Centre for Military Law, a collaborative initiative between the Melbourne Law School and the Australian Defence Force Legal Service. Tim has been a visiting professor at Harvard Law School twice and was the Charles H. Stockton Distinguished Scholar in Residence at the US Naval War College in Newport, Rhode Island. He served as the Amicus Curiae on international law issues in the trial of Slobodan and Milosevic in The Hague. And as such, it's my pleasure to introduce Professor Tim McCormack to talk on the topic of the International Criminal Court and between a rock and a hard place. Are we expecting too much of the ICC? Thanks very much, Tim.
Thank you, Matt, and thanks to the audience who've joined us from certainly around Tasmania, Australia, and I can see scrolling through the list of participants from around the world. I would also like to pay my respects to the Moornina people. I sit on their traditional land as I deliver this presentation tonight. In circumstances other than restrictions imposed as a consequence of COVID-19, we'd probably be meeting at the University of Tasmania and we would all be then gathering on the land of the Moornina people. But I know that for those of you, at least in Australia, where you sit to listen in to this webinar tonight, maybe it's not tonight wherever you are in the world, but in Australia tonight, you sit on the land of the traditional owners of the place you're in. And the infrastructure that enables us to conduct this webinar is physically located on Aboriginal land, and I pay my respects to their elders past, present and emerging. Thanks very much to the Australian Institute of International Affairs Tasmania branch for the invitation to deliver this lecture jointly with the University of Tasmania. It's a pleasure for me to do it. But let me make an initial disclaimer, because I am the Special Advisor on War Crimes to the Prosecutor of the International Criminal Court. But tonight I'm presenting this lecture in my personal capacity and not representing either the prosecutor or the institution of the court. And I hope that that will be understood. So nothing that I say can be attributed to her office or to the institution. Let me just start with a few basic facts about this institution, the International Criminal Court. We often describe it as the world's first permanent international criminal court, based, as Matt has said, in The Hague, although it's true that the court itself has shut down as a consequence of restrictions to COVID-19, and its staff, like so many other institutions around the world, my own, the University of Tasmania included, are conducting their work by virtual means. The International Criminal Court was established pursuant to the Rome Statute, a multilateral treaty that was negotiated in Rome 22 years ago this year in June through to July 1998. The Australian government had a very significant role to play. We were, through Richard Rose, Senior Legal Advisor to the Department of Foreign Affairs and Trade, a Tasmanian, graduate of the University of Tasmania Law School, I'm proud to say, were the chair of a group of states called the Group of Like-Minded States, a group of states from around the world, from every geographic region of the world, whose commitment was to a vibrant, rigorous, effective international criminal court, and who committed themselves to attempting to negotiate that in the 6-week diplomatic conference that was held in Rome. I had the tremendous privilege of joining the Australian government delegation for 2 of the 6 weeks of the conference, and that was an experience I'll never forget. Australia's been a strong supporter of the institution ever since. Kofi Annan, the then UN Secretary General, at the ceremony to sign the Rome Statute on the 17th of July in the Italian capital, said this, amongst other things, in his speech about the institution: "This new International Criminal Court is a gift of hope to future generations and a giant step forward in the march towards universal human rights and the rule of law." 22 years on, we'd say perhaps Kofi Annan was speaking aspirationally, and the International Criminal Court hasn't quite achieved that lofty ideal that he articulated so long ago. But let me try to place the court in the context of the historical evolution of international criminal law very briefly, not to focus on this, but to just provide some introductory words of context. In one sense, the International Criminal Court has emerged from a natural progression of evolution. The whole concept of the international legal regulation of the conduct of warfare dates back to the middle of the 19th century. But the very first proposal for an international criminal court or tribunal really emerged in the aftermath of World War I, when the Allies established a Commission on Responsibility for the War and for violations of the laws of war, then quite an established body of law, to be imposed on the defeated Central Powers, the Germany, the Ottoman Empire, Bulgaria, and each of the peace treaties that were imposed on the defeated Central Powers contained some clauses, some pro forma clauses that were replicated across those peace treaties, envisaging the establishment of Allied high tribunals to hold individuals criminally accountable. Those tribunals never eventuated. There was a political compromise done. It was more important to re-engage and rebuild Europe and also the areas of the Middle East and Central Asia that the Ottomans had ruled, than to engage in a punitive approach to criminal accountability for violations of the law. But then in the aftermath of World War II, of course, we know very much more about the establishment of the Nuremberg and Tokyo tribunals, and perhaps to a lesser extent, literally thousands of subsidiary trials conducted at the national level, including by, in our own case, Australian military tribunals conducting 300 war crimes trials of mainly Japanese defendants. That's sort of international criminal law 1.0 in a sense, the post-World War II period. We can skip on 45 years after that to the establishment in 1993 and 1994 by the UN Security Council of the International Criminal Tribunals for the former Yugoslavia and for Rwanda in those 2 years respectively. Perhaps we could say International Criminal Law 2.0, an advance on the Nuremberg and Tokyo model, long criticised as victors' justice, the winners of the war imposing a system of justice on the losers, to the UN Security Council, the executive arm of the multilateral community, establishing tribunals to try anyone, winners or losers, from the theatres of conflict in the former Yugoslavia. We've had a succession since then of so-called hybrid tribunals, a special court for Sierra Leone, the special tribunal for Lebanon. There have been multiple models of hybrid tribunals, all established for single conflicts to deal with the post-conflict justice issues arising. And now, or more recently in 2002, the entry into force of the Rome Statute negotiated in 1998, this time for a permanent international criminal court. That is one that is at least potentially has jurisdiction over alleged war crimes, crimes against humanity or genocide, wherever they've occurred in the world. Not set up ad hoc for a specific conflict, but as a permanent court to deal with multiple conflicts and the alleged crimes perpetrated. So that's the sense in which the ICC represents a natural progression from what went before it. But it's also true that the ICC is a qualitatively different creature than everything that preceded it, apart from the fact that it's not limited to a single conflict, that it potentially has open-ended jurisdiction, although the statute prescribes some limitations to that jurisdiction. It having been created by a multilateral treaty is controlled by its states parties. The Assembly of States Parties is the plenary body where all the states that have ratified or acceded to the treaty are members. And it's also true that this court represents an unprecedented threat to the sovereignty of individual sovereign nation states in a way that none of the other preceding tribunals has ever done. And here, the critical thing, and I'll come to explain a little bit more about how the jurisdiction works, is that the Rome Statute purports to give to the court jurisdiction over the nationals of non-states parties to the statute in some specific circumstances. I'll come to the details of that. That reality makes this court qualitatively different to all that's gone before. Of course, some people say, well, that's evidence of the evolutionary process of the development of international criminal law. Others would say, well, perhaps in the current multilateral environment, the world's not quite ready for such an institution. We'll consider those arguments. I think that one of the things I'm fascinated by is that there is a sense in which there are some irreconcilable tensions, irreconcilable expectations about what the court can actually achieve. On one hand, the court is expected to be ideal, that is, committed to ending impunity, to be punitive, to be principled, to be transcendental, and to be consistent in its application of the law. But at the same time, the court is also expected to be real, must engage with the Assembly of States Parties. It has to carry the support of the States Parties. It has to be grounded. It has to actually be effective and not just aspirational. That's one tension inherent in irreconcilable, some would argue, irreconcilable expectations. A second example is that there is a sense in which the court is a vertical regime. That is, it is supposed to engage in legal coercion. It's conducting criminal trials. It's punishing convicted individuals. But it's operating on a horizontal plane amongst sovereign nation actors who are very much used to a consensual-based system of international law. A third tension is that the court is supposed to be independent, and yet it is totally or thoroughly dependent. It has no police powers of its own to arrest individuals. I'm not advocating that it should have them, merely making an observation that it is completely dependent on states, on multilateral organisations, on UN peacekeeping missions, whatever other authorities that are capable of taking individuals into custody and physically transferring them to the Hague. The court has no jurisdiction over trials in absentia. It must have the individual accused physically before it. It's also true, a fourth tension is that the court is required to be effective, but it also has to grow its legitimacy. And we're still, with 124 states parties, slightly short of 2/3 of the world's sovereign nation states as states parties to the Rome Statute. I thought might be helpful if I could explain briefly to the audience about how the court's jurisdiction works, how a case actually comes to the court, and the scope of the jurisdiction built into the Rome Statute to then give us an informed basis for assessing some of the current tensions and challenges and very controversial issues that the court is confronted with. So David, if we could please have the first slide, Article 13 of the Rome Statute. In this provision of the Rome Statute, we see that a case or proceedings before the court must come by one of three alternative, what we call triggering mechanisms. First of all, a state party may refer a situation to the court. So this is Article 13A, a situation in which one or more of the Rome Statute crimes appears to have been committed is referred to the prosecutor by a state party. And the reference is to Article 14, which sets out the process of that that state party referral. The second triggering mechanism, an alternative to the first, is the situation where one or more of the Rome Statute crimes appears to have been committed and is referred to the prosecutor by the UN Security Council, acting under Chapter 7 of the Charter of the United Nations. And the third option, where the prosecutor has initiated an investigation in accordance with Article 15. And if we were to go to the terms of Article 15, we don't need to for tonight's purposes, but if you were to look at the provisions of Article 15, you see that the prosecutor has what we call ex proprio motu powers, a discretion. If neither of the first two triggering mechanisms happen, the prosecutor has discretion to go to the pre-trial chamber of the International Criminal Court and request three judges to approve the opening of a formal criminal investigation. It's a sort of check and balance on the power of the prosecutor. In either of the first two triggering mechanisms, the prosecutor needs no such approval from the pre-trial chamber. It's enough that the situation has been referred either by a state party or by the UN Security Council. And interestingly, to look through the situations currently on the court's docket, we see that there have been state party referrals in respect of the Democratic Republic of the Congo, Uganda, the Central African Republic, Mali, and Palestine. UN Security Council referrals under triggering mechanism 2 in the situations of Darfur in Sudan and also in Libya. And then proprio motu requests for opening of a criminal investigation, all of them approved, in the cases of Kenya, Cote d'Ivoire, the Ivory Coast, and Georgia and Afghanistan. Now, in addition to one or other of these three triggering mechanisms, only one of them is required, but one of them must have occurred before the prosecutor can open a formal criminal investigation. There are two additional admissibility criteria, and David, if we could move to Article 12, please, on the next slide. The first additional admissibility criteria is the consent of a relevant state in respect of triggering mechanism 1 or 3, that is, state party referral or the prosecutor acting on her own initiative. So in Article 12, the statute specifies in paragraph 2 that in relation to Article 13A or C, triggering mechanism 1 or 3, the court may exercise its jurisdiction in one or more of the following states are parties to this statute or have accepted the jurisdiction of the court in accordance with paragraph 3. And the two states in question are the territorial state, the state on whose physical territory the alleged crime occurred, or the state of nationality, the state of whose the accused is a national. If either of those two states, and the provision here specifies that only one of them is required to have given their consent, if either of those two states have consented to the court's jurisdiction, the court has that consent and the prosecutor can proceed. The alternative to if either of those states, the territorial state or the state of nationality, are parties to the statute, that is, they've ratified or acceded to the statute, then the court has their consent. If neither of those states has ratified or acceded to the statute, nevertheless, that state can accept the jurisdiction of the court by declaration under Article 12, paragraph 3, which is an alternative mechanism for the expression of consent. Interestingly here, Article 12 and the precondition of consent to the court's exercise of jurisdiction is not applicable to triggering mechanism 2. And what the statute is doing is reflecting the constitutional authority of the UN Security Council, because we read in Article 13, 1b, that when the Security Council refers a matter to the prosecutor of the International Criminal Court, the council can do that, acting under Chapter 7 of the UN Charter, that is without the consent of the state concerned. So you have in this structure of the court's exercise of its jurisdiction, the ability for the Security Council to refer a state which is not a party to the statute to the prosecutor for the prosecutor's consideration situation involving that state. That's the first additional admissibility criterion that accompanies one of the three triggering mechanisms. The second admissibility criterion is in Article 17. If we can move to that slide now, please, David. Article 17 talks about additional issues of admissibility. The particular one is the so-called complementarity formula. Some of you will have heard that term, some of you will be very familiar with it. It's not a term that appears anywhere in the Rome Statute, although, as we see in Article 17.1, the reference is to both paragraph 10 of the preamble and Article 1 of the statute. In both of those two provisions, the Rome Statute talks about the court as a complement, that is C-O-M-P-L-E-M-E-N-T, not C-O-M-P-L-I. It's not, you look great today, but this is a complement to or a supplement to national jurisdiction. The word complementarity has been coined to encapsulate the relationship between the ICC and national courts. And what the statute says clearly in Article 17.1a is that the International Criminal Court only has jurisdiction where either of the relevant states, that is the territorial state and the state of nationality, where both of them are unwilling or unable genuinely to carry out the investigation or the prosecution themselves. This is a test that applies to all three triggering mechanisms, even to UN Security Council referral, even when the council refers a situation to the prosecutor, the territorial state and the state of nationality, if they are in fact two different states. In many cases, of course, they'll be one and the same. But even if they're two different states, both of them have a better claim to jurisdiction than the International Criminal Court does. Now, sometimes I think it's worth thinking about, what does this combination of provisions, Article 13, 12 and 17, 1a, mean for example, US concerns about why the jurisdiction of the court is unacceptable? And I've tested these scenarios on audiences in the United States. From my perspective, the major concern that the US has is not the prosecution of clear-cut cases of war crimes by US military members. I mean, the most glaring example in the last few years, perhaps, arguably, has been Sergeant Bales walking out of his military base with unauthorised with his weapon, going into a nearby village and executing 17 unarmed Afghani civilians. And Sergeant Bales was rightfully charged with 17 counts of murder and convicted of all of them. I don't think the US is concerned about this sort of scenario where a member of the US military commits a war crime and the processes exist under the Uniform Code of Military Justice for the trial to occur. But there are two other key concerns that the US has. One of them is, in this scenario, what if the prosecutor of the International Criminal Court believes that the United States is unwilling to go up the chain of command to those most responsible, in the view of the prosecutor, most responsible for the perpetration of war crimes? Perhaps Abu Ghraib and the atrocities that occurred in that prison facility in Iraq would be a good hypothetical example, not that it's an actual example, because Iraq was not and still is not a state party to the Rome Statute. So the court does not have jurisdiction over what occurred in Iraq, except conduct in alleged violation of the Rome Statute perpetrated by nationals of states parties. In case of Abu Ghraib, neither Iraq nor the US the territorial state and the state of nationality in relation to the detention facility in Abu Ghraib were parties to the statute. So the court doesn't have jurisdiction, didn't have and doesn't have. But hypothetically, if Iraq had been a state party to the Rome Statute at the time the atrocities occurred in Abu Ghraib, then the International Criminal Court would have had jurisdiction because Iraq would have consented to the court's exercise of jurisdiction as a territorial state. Now, we know that the US military investigated alleged war crimes perpetrated in Abu Ghraib and went as far up the chain of command as Brigadier Karpinski, who was the one-star officer in charge of the detention unit. And she was demoted to colonel, and that was the end of her military career for all intents and purposes, at least in terms of promotion up through the ranks. What if the prosecutor believed that actually it was important to go further up the chain of command than Brigadier Karpinski, to look at the Secretary of Defence, perhaps, then Donald Rumsfeld, who signed the infamous torture memo in respect of interrogation practices at Guantanamo Bay that were transferred to Abu Ghraib prison? Or what if the prosecutor believed that the three-star general in charge of the military operation in Iraq should be the one to be investigated? There's, in my view, real concern in the United States that the prosecutor might want to go further up a chain of command if the court had jurisdiction, and say that in those circumstances the US is unwilling to carry out the investigation of those allegedly most responsible. A second scenario is, what if the United States believes that war crimes have not been perpetrated? There's been investigation, no one's been prosecuted, because from the US perspective, the operation has been conducted consistently with rules of engagement. And the prosecutor of the International Criminal Court takes a different view of that. And let's say the court, hypothetically, has jurisdiction because the alleged conduct occurred on the physical territory of a state party to the Rome Statute. So, for example, in a military bombing, in an aerial bombing campaign conducted by US targets, Human Rights Watch and Amnesty are quick to point out that certain bombing incidents represented disproportionate military attacks. The US believes, after its investigation, that there might have been a mistake about the identity of the target, but the operation was carried out consistently with the rules of engagement. But the prosecutor takes a different view of it because of the influence of NGOs that are very critical of the targeting decisions that were made. Those two scenarios are both scenarios of great concern to the United States. And of course, this is not a hypothetical question anymore, because we know that the appeals chamber of the International Criminal Court approved just a couple of months ago the opening of a formal criminal investigation into conduct perpetrated on the physical territory of Afghanistan. And I'll come back to that particular case study in a few more minutes. I think it's worth trying to sort of unpack the tensions that I identified earlier on, some of the irreconcilable expectations, by reference to each of the three triggering mechanisms in Article 13 that we already looked at. And here I'm drawing unashamedly on the work of Darrell Robinson, professor in Canada, who was friend of the chair in the Rome Statute negotiations on the definition of crimes against humanity, and done a lot of work on ICC and Rome Statute issues since. And Darrell wrote a really wonderful article which he published a few years ago, which he described, or the title is Inescapable Dyads. And it was basically how unpacking this sort of concept that there are some irreconcilable expectations placed on the court that will be impossible for the institution to satisfy, just because they truly are irreconcilable. Let's try and sort of make some application of otherwise potentially amorphous or abstract concepts. First thing I'd say is that in situations where the International Criminal Court has no jurisdiction, the issues are less challenging. There might still be expectations that the International Criminal Court will step in, and the Syrian crisis that's gone on since 2011, now entering its 10th year last month, is a really good example. I mean, if there's one situation in the world that the International Criminal Court should have jurisdiction over, it must surely be the crisis in Syria. We think about all the atrocities that have been perpetrated there, the use of chemical weapons in warfare, the use of high explosive ammunition in densely populated residential areas, the deliberate targeting of hospitals, the use of siege warfare to starve a population in a city, to force it to evict the city so that troops can go in. One atrocity after another in terms of violations of the law, but the court has no jurisdiction. I mean, it's understandable why people would say, well, why is the International Criminal Court interested in this situation or that situation, but not doing anything about the Syrian situation or the Iraqi situation or the situation in Myanmar, including the perpetration of persecution and atrocities against the Rohingya. But the problem is, or the reality is, that the court is unable to do anything about those situations. And it's a relatively easy response to be able to say, well, I mean, the fact is you don't understand the limitations to the statute of the court. And once you look at the combination of Articles 13, 12 and 17, you understand that in these circumstances, short of UN Security Council referral, the court has no jurisdiction. But what about where the International Criminal Court does have jurisdiction? And in these sort of circumstances, if we think about each of the three triggering mechanisms in turn, I think we start to see how these irreconcilable expectations really create incredible challenges for the institution of the court. Firstly, in relation to state party referral, the first triggering mechanism in Article 13. So if the prosecutor says, yes, thank you, I really appreciate the referral, now we're going to open a formal criminal investigation, then the allegations could be the prosecutor's pandering to state interests. There's a lack of independence by the prosecutor. The prosecutor's only sucking up to the governments who self-referred. I remember when Mr. Ocampo, the founding prosecutor of the International Criminal Court, first received the referral, the self-referral from Uganda, and he publicly said that the Ugandans had tried to refer only the Lord's Resistance Army. And Mr. Ocampo said, well, I can't accept that. The referral has to be of the situation, and it's up to me to decide who are those most responsible for alleged atrocities in this context. But there are also arguments the other way. So if the court was to say, if the prosecutor say, well, no, I won't accept the self-referral, then the criticism is, well, how can the ICC refuse to take on situations when it's asked to do so, and when the very states that have a better claim on jurisdiction are pleading with the court to help them with the challenges that they face? Now, of course, Mr. Ocampo's position on Uganda is right and proper in principle. But when we think about the self-referrals from the Democratic Republic of the Congo, from Uganda, from Central African Republic, and from Mali, there is still yet to be a situation where a member of the government forces in any of those situations is the subject of an arrest warrant. And that, of course, raises different questions in itself. I'm not trying to suggest that there's anything improper here. Maybe, I'm sure the prosecutor believes that she doesn't yet have sufficient evidence to be able to bring the case against a particular member of the government. But of course, the criticism is that the office of the prosecutor is dependent on cooperation of states. So either there's a pragmatic approach or a political approach. I'm sure it's neither of those things, but I can understand why the criticisms are made, that this is about what's possible in the circumstances, because the court requires the cooperation of the authorities to be able to investigate the situation. And it raises some real challenges about where the balance is in the approach that's taken, that must be seen to be independent of political influence and fair and based on evidentiary grounds. The second triggering mechanism is UN Security Council referral. If the referral makes the office of the prosecutor if the first triggering mechanism, that is self-referral by states, if the allegation is that makes the Office of the Prosecutor too close to the individual states who may be not only concerned, but the subject of allegations of their own atrocities, then at least the second triggering mechanism, the Security Council, is at greater arm's length from the prosecutor, much more independent of self-serving interest. Well, maybe not, because the allegation here is that the prosecutor, in taking on the UN Security Council referral, is doing the bidding of the 5 permanent members of the Security Council. There's a sort of north-south challenge here, because we all know that the Security Council will never refer Guantanamo Bay or Chechnya or Tibet or Syria, where Russian forces are physically involved in the fighting, or Myanmar, or any other situation in the world where one of the 5 permanent members has a vested national interest. But the criticism on the other side is that, well, the fact that the Rome Statute crimes are going on elsewhere in the world doesn't detract from criminal responsibility in Darfur or Libya, the 2 situations referred by the Security Council. And I mean, the prosecutor should still take those situations on and live with the criticism that, you know, this is only dealing with vested interest or vested disinterest by the 5 permanent members of the Security Council. Yes, perhaps. But one of the challenges in relation to UN Security Council referrals is that there is not yet a single accused from either Darfur or from Libya in the custody of the court at the moment. And it's clear that the Security Council members have been unwilling to take substantive action. Gaddafi died before he could be physically transferred. The fighting in Darfur has settled down, not as bad as it was back in the early 2000s or mid 2000s. And so the International Criminal Court can be a fig leaf for UN Security Council indifference, with the Security Council's given the prosecutor the authority to investigate, but then hasn't backed that up with substantive action to put pressure on for the surrender of states or by international organisations of those accused who are identified in arrest warrants that the court has issued. And this creates a problem of perception of inefficacy on the part of the International Criminal Court. The court's reduced to giving states parties who've welcomed former President Omar al-Bashir of Sudan to their capitals for various intergovernmental meetings that they've hosted. I mean, some criticism has even been directed at Mr. Ocampo because the 2 Security Council referrals in respect of both Darfur and Libya included exclusion clauses that excluded the nationals of non-states parties who are engaged in peacekeeping operations in either country. And the criticism is, well, why wouldn't Mr. Ocampo reject those referrals and say, I'm not going to accept them because they are limited. I reserve the right to investigate those who I think are most responsible for the atrocities on the ground in both situations. So these criticisms in relation to triggering mechanism 1 and 2 must leave us with the view that the best alternative, the least controversial alternative triggering mechanism, is the prosecutor exercising her own discretion proprio motu. But no, again, there are arguments both ways about this. Some people would say the International Criminal Court is not prepared to stand up to states. It's timid and it's pandering to state interests by not referring more or not seeking more proprio motu authorizations to open criminal investigations. But others would say, no, the ICC is intervening without invitation and without support, and it'll be ineffective. It'll lose credibility if the prosecutor acts on her own initiative to ask for approval to open formal criminal investigations. The ICC is ignoring legitimate state interests, the criticism would run. The first 3 situations where the prosecutor sought and gained approval for the opening of investigations were Kenya, the Ivory Coast, and Georgia. But not for years in relation to Afghanistan or more recently Palestine. Now those 2 situations have probably become the most controversial in the court's history. Some people previously, before the prosecutor lodged her request lodged her request for approval to open a formal criminal investigation into the Afghanistan situation, would argue that she was being too deferential to states, while others would say she hasn't been deferential enough, that she's been too reflective of powerful state agendas, while others would say that she's acted in a way that's been disruptive of those states' agendas. The reality is that these two situations, I think, raise the most controversy that has confronted the court. This is not a reason for prosecutor not to deal with them. All I'm trying to do is explain just how sensitive some of these issues already are. Let me explain a little bit more about both these two situations, because both of them involve nationals of non-state parties. Not the first time that the court has opened a formal criminal investigation into a situation that involved the nationals of a non-state party. First time that happened was when the prosecutor also exercised her proprio motu powers in Article 13C, when she sought and gained approval to open a formal criminal investigation into the situation in Georgia. And there, of course, Russian government forces had invaded the two northern provinces of Georgia, Abkhazia and South Ossetia. In relation to Afghanistan, the situation is very interesting. The successive prosecutors had a preliminary examination into the situation for 10 years. And then finally, in November 2017, the prosecutor requested from the pretrial chamber authority to open a formal criminal investigation. The pretrial chamber took 15 months until April 2019 to make a decision about whether to grant that approval. That's an incredible period of time. The Georgia application was made and the approval given within 2 months of the request, 15 months. And then the pretrial chamber decided by majority not to grant the approval. It's a very low threshold test, reasonable basis for believing that Rome Statute crimes were committed. And the pretrial chamber decided that because there was no reasonable prospect of trials being conducted in relation to the Afghanistan situation, they would not grant the prosecutor's request. Now, some people applauded that decision and other people completely opposed to it. And both of them, coming at the issue from meritorious and substantive grounds. The prosecutor appealed that decision of the pretrial chamber, and in March this year, just a few weeks ago, the appeals chamber of the International Criminal Court granted approval to open a formal criminal investigation. And those of you who followed it know very well the reaction of the Bush administration. Secretary of State Pompeo, just a couple of months ago, named 2 very senior officials in the office of the prosecutor who would be banned from entry into the United States. This very serious response at the possibility that the prosecutor could investigate alleged American Rome Statute offences on the physical territory, allegedly occurring on the physical territory of Afghanistan. Second situation is Palestine, and here also there are great controversies. The reality is that in 2009, the Palestinian Authority deposited a declaration under Article 12, Paragraph 3 of the Rome Statute, accepting the jurisdiction of the court. The prosecutor, Mr. Ocampo at the time, opened the opportunity for submissions from any interested parties, individuals, groups, organisations, states, to respond to that request. And on the basis of the gathering of those submissions, the inquiry that was undertaken subsequently, in 2012, the prosecutor announced that because of Palestine's uncertain international legal status, that declaration was invalid, but that if the Palestinians went out to the multinational community, multilateral community, I should say, and were able to clarify their international legal status, then they were welcome to come back to the court at some future stage. So in response to that decision, the Palestinians were admitted to membership of UNESCO. They also gained an elevated status at the UN from observer to non-member observer state alongside the Holy See in late 2012. And then in 2015, the Palestinians came back to the International Criminal Court, this time acceding to the statute on the 2nd of January 2015 and becoming a state party. The UN Secretary General is the depository for accessions to the instrument, circulated that instrument of accession. The Canadians were the only state party that objected to that on the basis that they didn't believe Palestine was a state. Other states parties, including Australia, said that the accession of Palestine as a state party to the Rome Statute did not determine Palestine's legal status. On the 16th of January 2015, the International Criminal Court Prosecutor announced the opening of a preliminary examination into the Palestinian situation, and then, having begun that preliminary examination, in May 2018, the Palestinians referred the situation to the prosecutor under Article 13A, a state party self-referral. On the 20th of December 2019, the prosecutor announced that she believed there were reasonable grounds for reasonable grounds for believing that Rome Statute crimes have been committed, which is the threshold test for the opening of a formal criminal investigation. But before doing so, she lodged a request with the pretrial chamber of the International Criminal Court to determine whether or not the court has jurisdiction. And perhaps, David, if you can put up Article 19, we just look very briefly at paragraph 3 in particular. The prosecutor may seek a ruling from the court regarding a question of jurisdiction or admissibility. And the prosecutor said to the pretrial chamber, we want to know at this stage of proceedings whether or not the court believes that it has jurisdiction over Palestine. The prosecution has articulated its arguments in relation to that issue, and they are two, basically. First of all, that Palestine is a state party of the Rome Statute and that does not determine its broader international legal status, but that it is a valid state party because its accession was accepted by the rest of the states parties, except for Canada. And in the alternative, that Palestine is a state for the purposes of the Rome Statute consistently with international law. But the prosecutor believes that the decision should be made by the pre-trial chamber on the question of jurisdiction. And rather than undertake the formal criminal investigation, this is an issue that should be decided at a preliminary stage. That is a very contested decision because some people say she should just get on with the job that she's been given, and other people would say she should do what she was appointed to do, and that this is an inappropriate place for the course of action that she's proposing. That the International Criminal Court can't decide on issues like those in Palestine because there is a peace process going on between the parties to the dispute. And of course, if the court exercises jurisdiction over the physical territory of Palestine, the court will be looking at conduct not only in Gaza, but also in the West Bank and East Jerusalem. What to make of all of this, these challenges confronting the court in very, very sensitive circumstances? How does it help to actually identify and attempt to explain that everything is so contested? It's pretty bleak and foreboding that it doesn't matter what decision the prosecutor makes in these sorts of situations, there will always be people of genuine commitment to a viable international criminal court who disagree with that decision. I think in identifying the contests and the sensitivities, we can deepen the debate around the work of and the efficacy of the court, although we will never agree on exactly what the right decision for the court is. I've asked myself, does this represent an existential threat for the institution of the court? That perhaps in the current multilateral environment, the world just isn't ready for an international criminal court that has the authority, because of the way the jurisdiction of the court has been drafted, to actually override state sovereignty in the case of nationals of non-state parties. The League of Nations, for example, was ahead of its time, and it ended up not surviving the outbreak of World War II, which it was set up to prevent in the aftermath of World War I. Perhaps we aren't ready for an international criminal court that's effective. I hope not. I'm not suggesting that that's the reality. I sincerely hope not. I work for the institution and I believe in the institution. And from my perspective, the most important task that the prosecutor has is to act on the basis of the evidence that she has before her. And if the UN Security Council, for example, believes that the prosecutor acting on the evidence before her should actually cease and desist for other political grounds, on the basis of threats to international peace and security. The Security Council is the body invested under Article 16 of the Rome Statute to step in and to stop proceedings or suspend proceedings for 12 months, which can be renewed subsequently. Ultimately, it's for the Assembly of States Parties and the Security Council, to a lesser extent, the Assembly of States Parties as the plenary body of the states that make the International Criminal Court function, to determine things like how much support they will provide, the level of resolve amongst them to assist in the taking into custody those who are accused and still at large, to determine the quality of the nominees for positions of judge and prosecutor, to allocate financial resources to enable the court to do its work. And for the personnel of the International Criminal Court themselves, their responsibility is to act professionally on the basis of the evidence that they have before them, knowing full well that every decision they make, especially the decisions of the prosecutor, will be contested by one or other person, or in many cases by both sides of a particular position. Thanks very much, and sorry to have taken so long, Matt. I look forward to some questions if we have some time.
Not at all, Tim. That was extraordinarily engaging. You covered a huge breadth of material in a quite complicated institution and made it in a comprehensible and tangible manner. We've got one question I'd like to start off with, and I'd encourage people to post questions in the 10 minutes that we have left for Q&A. So, Tim, the first question is from Elliot, who asks, how can one maintain confidence not only in the International Criminal Court, but in international law in general, when the states who commit some of the greatest violations of law routinely are not held to account? So this obviously taps into one of the earlier themes that you addressed in your presentation.
Yeah, thanks for the question, Elliot. And I ask myself that question regularly. I feel like in a situation, a crisis like that, which has engulfed Syria over the last 9 years, and we're heading into the 10th year, as I said, where especially international humanitarian law has been regularly violated. I mean, almost on a daily basis, weekly basis, one atrocity after another by multiple parties to different sides of conflicts within Syria. I ask myself, what does it do to the normative standard of international humanitarian law for it to be violated on such a regular and egregious basis with no accountability for those allegedly responsible? And I find that a very demoralizing question to ask, because I feel like it is a huge threat to our acceptance of these norms, that they can be so routinely violated and with apparently no accountability or consequences for those responsible. I guess my answer is that the international community has a responsibility to condemn those atrocities. The International Committee of the Red Cross regularly does so. And it is the responsibility of the international community, especially all the states parties to the Geneva Conventions, to ensure that they not only condemn the atrocities, but when alleged atrocities occur, or at least are perpetrated by their own nationals, that they take those very seriously. And so for me, the inquiry that's going on into allegations of violations of the laws of war by members of the SAS in Afghanistan is a really critical test for us in Australia. Are we going to demonstrate that we believe this body of law is really binding upon us and take it seriously and ensure that once General Brereton has concluded his report, that on the basis of his recommendations, incidents are properly investigated, or are we not going to do that? And it will be up to countries like us to stand up to say this body of law is still real and meaningful for us, even if it's being violated by others.
Our next question is from Sean, who asks, regarding the exercise of the court's jurisdiction in relation to non-state parties, do you think the court has a role to play in closing an accountability gap? And this question is in particular light of recent events in Afghanistan that you were alluding to in your presentation.
Well, as a general proposition, yes, I do. I think the court has a role to play in closing an accountability gap. It's also important to understand that the state of nationality, which may not be a state party to the Rome Statute, has a better claim on jurisdiction than the ICC. So the complementarity formula in Article 17(3) still applies even to non-state parties to the Rome Statute. So if there are alleged Rome Statute crimes that have been perpetrated by them, they have a better claim on jurisdiction if they choose to exercise it. One of the challenges in relation to the US and the International Criminal Court in respect of conduct in Afghanistan. So Afghanistan has been a state party to the Rome Statute since 2003. So the court has had jurisdiction over what happens on the physical territory of Afghanistan since that date. One of the challenges is that the prosecution has said to the American authorities who've consistently argued and claimed that they have investigated alleged war crimes on the ground in Afghanistan, show us the material so that we can be satisfied that Article 17 complementarity requirements have been met. And the Americans say, well, we aren't allowed to cooperate with the court, so we can't show you any of the material. It's a bit of an impasse there. But I think it's true. It's a very important proposition of truth that non-states parties, as the state of nationality or the territorial state, in some circumstances, have a better claim on jurisdiction than the ICC. And if they exercise it, that should be the end of the matter. The court has no room to exercise its jurisdiction because responsibility has been taken at the national level, which has the stronger claim.
Brilliant. With an eye on the time, I've got a few questions backed up, and there's three in particular that I'd like to get to. The first is from Christina, and her question regards the quite controversial interest of justice test that was heavily criticised in the pre-trial chambers ruling with respect to Afghanistan, and she would like you to develop or delve deeper into this particular test, and she asks what future it sort of has in future investigations and preliminary investigations.
Yeah, it's a great question. I think I might know who the Christina is because I scrolled through a list of of participants, and I'll take the opportunity to send a big shout out to her. I hope everything's well for you and the family in Sydney, Christina. And thanks for lots of great times together in The Hague. It's a really, really great question, and I didn't deal with it it comes up in Article 17 as another question about admissibility. There is this reference to the fact that in the interests of justice, a decision can be taken not to proceed with the opening of a formal criminal investigation or with the initiation of proceedings. And that's a really, it's a fascinating and challenging concept. In what circumstances might the prosecutor decide, or a pre-trial chamber decide, or perhaps more importantly, in my view, the UN Security Council under Article 16 decide that actually proceeding with criminal investigation, the issuance of arrest warrants and the possible conduct of criminal trials will not help in this particular situation. So, I mean, one example that I think is really really pertinent here is in relation to the first prosecutor, Mr. Ocampo's decision to issue an arrest warrant or to seek approval for. He doesn't issue them. He has to get the pretrial chamber's approval for that. But he sought and gained the pretrial chamber's approval to issue an arrest warrant against the then incumbent president of Sudan, Omar al-Bashir. And a lot of individuals and organisations, especially within the UN system, were scathing of that decision because at the same time, the UN was trying to negotiate a peaceful resolution of the conflict in the south of Sudan. Darfur is in the west, but in the south, now we know South Sudan is an independent country. Back when the arrest warrant was issued in 2009, there were very delicate and sensitive negotiations going on, and many people in the UN system believed that the prosecutor would only throw a sort of spanner in the works, if you like, of the negotiations for a peace settlement by daring to take the president of Sudan on by the issuance of the arrest warrant. Now, Mr. Ocampo's response to that criticism was, it's my responsibility to act on the evidence that I have before me. And if the UN Security Council really believes that proceeding with trying to gain physical custody of President al-Bashir, back then it maybe didn't look as forlorn as it turned out to be over the following decade or more, but proceeding with attempting to gain physical custody of President Bashir, if that is going to interfere with the peace negotiations in the south of Sudan, that's the Security Council's call. Because under Article 16, in the interests of international peace and security, maintaining or restoring international peace and security, the Security Council has the discretion to adopt the resolution to suspend ICC proceedings. They should do that. And if they do, of course, we're bound by that because that's what the statute says. So I think there could well be circumstances in the future where the Security Council makes that call and says these proceedings should not go ahead because they're not in the interests of justice and of peace, which they might add, and we're going to stop them. What the circumstance in which the prosecutor would decide that, I think, are less clear cut.
Tim, you're probably well aware the current prosecutor's term is coming to an end.
Yes.
And there's been a lot of discussion. In fact, there was a symposium, I think, on the Opinio Juris website about the various debates about the next prosecutor. Fiona has asked, what qualities do you think the next prosecutor will need to bring to the job to help guide the OTP through the next years?
Yeah. Well, I've had the privilege, Matt, of working for the last few years of Mr. Ocampo's term as prosecutor and for all of Mrs. Bensouda. She very generously asked me to stay on as Special Advisor on War Crimes. That's been an enormous privilege of mine to serve in that capacity throughout her entire term. But from my perspective, the decision that the Assembly of States Parties will take at the end of this year for commencement of the new prosecutor's term in the middle of 2021 is one of the most important decisions for the future of the court. And one of the key qualities that the incoming prosecutor must have is a very, very thick hide. Thick skin, not to take personally the pressures and the criticisms that person will undoubtedly be subjected to for all the reasons that I've been talking about tonight. That person has to be capable of independent decision-making on the basis of the evidence that they have before them, and not to be swayed or influenced by counter views either way about every decision he or she will make. I think it's really important that the new prosecutor has extensive prosecutorial experience, national and perhaps also at the international level, but it's a really multifaceted role, and there is a diplomacy aspect to it, but there is also, I think, a really important part about the preservation of the independence of the office, which requires a person in that position to be able to make their own calls on the decisions that they have to make that will never please everybody and sometimes displease almost everybody.
We have one final question. This is from Paul, who's listening in from Ireland. And Paul has asked you to wave your ICC wand and what is it that you would change if you had said ICC want?
Paul, thanks for listening in from Ireland, the land of my forebears. My great-great-grandfather was transported to this beautiful place that I now live in 175 years ago this year. 14 years hard labour in Van Diemen's Land for assaulting his English superior officer who was in the Irish regiment. And it's lovely to have an Irish person listening in. Thank you, which is not answering the question at all, I know, but I couldn't resist it. If I could wave the wand, I mean, there's a few things that I think I would really want to see happen differently. I think it's, perhaps I can just briefly mention them. I really hope that the Assembly of States parties take seriously the importance of electing the very best judges that they can, as well as a very best prosecutor that they can get, because those appointments are critical in terms of decision making about really challenging issues of law in the context of capital P politics. I think there's some really important efficiencies that need to be improved about procedures and the length of time that things take. And it frustrates me that the pretrial chamber could take 15 months to make a decision on a request like the opening of a formal criminal investigation into Afghanistan. Even though it's a challenging decision, shouldn't take 15 months. I don't think judgments should take more than a year to be delivered after the end of trial proceedings. I know there have been complications in some cases with illness on the part of judges, but there are some things that have to be improved in terms of efficiencies. I'm identifying time delays between requests or ends of trials and decisions or judgments, but there are also many within the process itself that need to be rectified so that the court becomes more efficient in its ability to deal with what are invariably complex cases. And I think every organ of the court has responsibilities in relation to improved efficiencies. I, of course, know the prosecutor's work much more closely than I do the chambers or the defence counsel or the registry. But I think there are really important improvements that need to be made to allow the court to grow in its credibility as a arbiter of criminal responsibility.
Wonderful. Unfortunately, we're out of time because I imagine there are more questions that people would want to ask. I know I've got a heap of questions that I'd like to ask. It's important for events like this. There are a number of people that we need to thank for putting them together. My first thanks is to the AIIA Tasmania branch for hosting and approaching Tim. I encourage you to keep an eye out for our upcoming events, and you can see from the slide that's up here now, the next UTAS AIIA event is Professor Nicholas Farrelly, who's going to be talking about tomorrow's strategic engagement with Asia. Also, a big thanks to the UTAS events team for putting this evening's event together. And finally, a massive thanks, of course, to Professor Tim McCormack for his insights and his time in talking to us this evening about, I guess, an institution that I personally, when you look back at its history, was created in such a period of optimism, and yet there are really quite pragmatic limitations to what it's able to do. And Tim's been able to highlight all of those for us this evening and demonstrate what it can and can't do. So thank you so very much for that, Tim.